as she said. Okay, just want to mention JASM thing a little bit. We are going to have online Mondale Gala this year, yet again. This year, we are dedicating a gala to Mr. Mondale for the everything that he has done for us. And we have a many special guests giving us words, such as Senator Klobuchar, Ambassador Tomita, and Consul General Tajima, who has just got here. And we also are gonna have to get to listen to the story of Minnesotan who was a soldier during the World War II, and he comes back and then he get reconnected to Japan in a more positive way with the help of Mr. Mondale. It's a quite beautiful story that I'm looking forward to share all of you. And Yoko-san, if you can share the website link. Our link is up. If you would like to register, please to do so. And we have wonderful items for auction that you can purchase. And also you can donate for JASM and also the scholarship, Mondale Scholarship, that we got okay from the family to continue using Mr. Mondale's name, and we're very thankful for that. So yes, please check out our gala. I think it's going to be great, and we just spend a day having a professional people making a video of us, and I learned how difficult it is to be a newscaster. I'm glad that I have this job and then not that. That was really hard. So without further ado, we have Mr. Doug Mueller from HSML and also the team of HSML office. Please take it up.
Well, thank you. And I will share my screen so you can see the presentation that we prepared and not see so much of me, which is probably a good thing. Okay, HSML, very cleverly named after the four founding partners, Hamre, Schumann, Mueller, and Larson. Very typical for law firms, so there's no significance to the letters other than that. We're an intellectual property law firm, and today we want to talk to you about some of our experiences in working with Japanese entities, companies and universities and the like in obtaining intellectual property rights for them. I think that our experience as a service provider working with entities who are in Japan may also have some broader relevance, maybe perhaps a little bit different experience from the people who are in more of a commodities or manufacturing business. Okay, first we'll have just a brief introduction of who is HSML. As I said, we're an intellectual property law firm founded in 2005 in Minneapolis by four attorneys who had been working together for various amounts of time at a larger intellectual property firm in Minneapolis. We've grown from about 12 people when we started to about 50 now. And the firm's practice from its beginning has been focused on international and domestic intellectual property law, typically including patent, trademark, and lesser amounts of copyright, plus unfair competition, trade secret, advertising and branding, and then also computer and internet law. We continue with the practice that we started in 2005, but as the years have gone by, our work has expanded into more of the business side of intellectual property rather than solely focusing more on the procurement. So we're expanding our work in licensing and technology transfer, due diligence for business transactions, more work in freedom to operate as part of business planning, portfolio advice and counseling, and working with companies and establishing strategies as they're introducing new product lines and business segments. What else is HSML? We are also a business entity with diversity in its employees and its clients. We are a minority-controlled organization. We have employees who are fluent in Japanese, Chinese, Spanish, French, German, Russian, and Hindi. And on our staff, we have 3 Japanese-speaking professionals and 2 Japanese speaking clerical staff, all of whom are on the call or the presentation today, and we'll introduce them in just a minute. We have been recognized by local and national bar associations for our diversity and inclusion in the practice of law. As a business, the majority of our work comes from North America and East Asia. However, we also have clients from essentially all over the world: South America, Europe, South Asia, and Australia. Our clients include multinational corporations, mid to small size businesses, startups, universities, and individuals. So it's a very wide ranging practice. We are also an organization with long-standing connections to Japan. When the firm was started, we had very significant connections with clients in Japan, and that has continued as we've gone through the years. Work from Japanese clients has accounted for over half of the US patents that have been procured by HSML since its founding. Before the adventures of the COVID era started, 2 of us were traveling to Japan twice a year for about 2 weeks at a time. Masako can continue to go back to Japan without as much trouble as it would be for me. And so she's been continuing to go back to Japan, although the ability to have in-person meetings with the clients is still not very good. So Masako, do you want to introduce our people who are here?
Sure. First of all, I would like to introduce our CEO, Brian Wan. Please, Brian.
Hi, everyone. Can you hear me?
Yes.
Great, thanks. Doug, if you wouldn't mind going to the first slide at the beginning of the presentation, I'd like to show our logo again. It has a lot of significance behind it. You may have seen our logo as in sponsorship with JASM or having met some of our people. But the inception of the firm was really one of an international practice, and Doug went through some of a lot of what we do. But this logo has a very big significance to us in that our perception, or what we have decided to show in the world here, is North America, including the United States, and then East Asia, where you see Japan. Covered up across is our founder's initials, HSML. The purpose of that in meeting is a bridge from the United States to Japan, also to other parts of East Asia, China, and so on. So from the very beginning, HSML has been a business that was founded on international practice, and frankly, Japan being one of those pillars and continues to be one of those pillars in our business. Japan's importance to us is evident from what Doug has shown. And with our long time contacts and work with Japanese clients and visits year in and year out, of course, until a couple of years ago or so, we have been able to bridge both ways as well and help our clients, people that are needing assistance in IP issues overseas, namely in Japan. And so we're very appreciative of this opportunity. I see a lot of familiar faces and look forward to the gala later this year, and also look forward to the in-person ones. Thank you to JASM and Rio-san for this opportunity. Rio, I'd like to just mention, we've mentioned your gala format to other organizations in town as a model for how successful it has been. So again, thank you. We appreciate this partnership with JASM.
Thank you so much. That's very nice of you. Thank you.
Thank you.
So is Sandy in the meeting? I would like to introduce our trademark head. Is she? If not, let's go to David. David is one of our partners, and he is working with our Japan practice team very seriously and rigorously. David, could you introduce yourself?
Sure, Masako. Thank you so much. My name is David Lee. I joined HSML about 2.5 years ago. I've been practicing for over 25 years, mostly in the DC market, but also in Seattle. I am back in the DC area. I live and work in Alexandria, Virginia, just a short distance from the U.S. Patent and Trademark Office. My practice has focused on patent preparation and prosecution, a mix of domestic and international clients. And yeah, I've just been very excited to join a firm like, well, not a firm like, but HSML. I love its international focus. I love the makeup of the firm, the people, and it's just been a real special opportunity. And appreciate you welcoming me to this forum this evening.
Thank you. Next is Hugo. Hugo is there.
Can everybody hear me? Yeah, good. I'm Hugo. I'm one of the patent attorneys with HSML. I started actually when HSML started, so been with the firm really from the beginning. Been practicing as an attorney. I started as a law clerk, so I was going to law school when I first started, and then as an attorney, I've worked with HSML since 2007, so it's been a while. I work with a mix of a lot of Japanese clients and of course US clients and from everywhere pretty much, and I enjoyed the work very much, and I cherish the opportunity to work with the firm.
Next is Naoko.
Yes. Hello.
Can you unmute the Asako-san's
Unmute.
mic?
Okay, sorry.
Sorry.
あさこさんが
Should,
Oh,
should we
oh, okay.
unmute here? Okay, it might be howling here again. But hi, I'm Naoko Koyano.
We're not hearing you right now. I'm wondering if Asako-san can unmute.
Okay, I did.
And Brian-san, can you mute? Let's see if that works at all.
So yeah, I would say 90% of my projects are from Japan, and I enjoy being able to help Japanese clients prosecute patents in US. Thank you.
So next is Satoko. Satoko-san, are you there?
Yes. Okay, hi. I'm Satoko Furuya, paralegal at HSML. I joined HSML about 3 years ago. And before that, I have worked at Japanese patent firm and the Japanese government, including Ministry of Economy, Trade and Industry and Japan Patent Office. I also briefly worked at WIPO headquarters in Geneva. I have a Master of Law degree here and Bachelor of Law degree in Japan. And I enjoy working with Japanese firms, Japanese companies, and also being here in Minnesota, especially this time of the year with lots of colors. I'm excited to be in this meeting today. Thank you.
And then Asako-san is the next person.
My name is Asakuna Kalchi. I joined at HSML about 6 years ago, and I am supporting Masako-san and Naoko-san and another attorney here. I really love the atmosphere of this company. As Brian said, we are multicultural people, and we can converse many important things in Japanese as well as English. And we are surrounded by other cultural people. So I really feel here at home. Thank you.
Thank you very much. And so these are our team working for Japanese clients mostly, and also the clients who have interest and want to do a business in Japan. So Doug, could you return to your presentation?
Yep. Let's see, let me get the slideshow working again. And I should add that there are more people in the firm. Well, actually, there are 2 more people in the firm, at least, who are on the call that didn't get specifically introduced. But the number of people in the firm who are actually working with the Japanese clients is quite large. We have 7 paralegals in the firm. 5 of them regularly handle work with Japanese clients. We have assistants for the professionals, all but 1 of them regularly handles work with Japanese companies. So the reach of the Japanese clientele into our firm is quite broad. I'd like to take just a couple of minutes to briefly explain what is intellectual property law and a little bit about how we do business, so that when we start talking about our relationship with Japanese companies and law firms, it might make a little bit of sense to you. This is very general information intended only to give you context about the activities of our firm. So please do not take this as an instruction about how to protect your intellectual property rights. You definitely need to go to something beyond this if you want to get serious about intellectual property. So the idea of what's property, it conveys the idea of rules that govern the ownership and transactions concerning things. The eighth commandment in the Judeo-Christian Bible, thou shalt not steal. So the idea of ownership and how do you transfer ownership, how do you obtain ownership. The idea of property in law typically is considered to have three branches. There's real property, which is the rules and regulations associated with land and things that are related to land. Personal property, which is the rules and regulations about tangible articles like your cell phones or computers or the clothes that you have at home. And then there's intellectual property, which is what we practice, and that is the law concerning rights in intangible things. Intellectual property usually falls into a category of a patent, trademark, copyright, and trade secret. The patents and copyrights are created by federal law, statutes passed by Congress. Article 1, Section 8 of our Constitution authorizes, but doesn't require, Congress to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, this exclusive right is a right to exclude others from taking some kind of action. It is not necessarily a right for the author or inventor to engage in any particular activity on their own. So it's very common that we will have a patent that's directed to a narrow improvement in some kind of technology that is giving very good results and is very valuable. If there is a broad, excuse me, if there's a broad generic patent that is still in force, you would not be able to practice your improvement patent without the permission of the owner of the broad and generic patent. So again, it's an exclusive right. You can prevent others from using your invention, but you do not necessarily have the right to practice the invention yourself. The constitutional provision does not put any particular limitations on how Congress should establish these exclusive patent or copyrights, other than a requirement that the right expire, so that the public will have free access to the patented invention or copyrighted work after the limited time expires. The intellectual property law is governed by the law in individual nations. There are some international agreements, but generally the law is country by country. So how do these main intellectual property rights differ? Well, the patent is a right to an invention, as we've discussed. A trademark is a word, phrase, symbol, design, color, and other things or combinations of them that serves to identify the source of goods or services that are being provided in the marketplace. So in essence, the trademark is recognizing the reputation that someone who is active in the marketplace has achieved through the marketing of these goods or services under a particular word or color or whatever. The copyright is a right that protects original works of authorship or artistic expression. The three are not mutually exclusive, and you can have a patent, trademark, and copyright that might cover a particular activity in some cases. So is it necessary to register intellectual property? In the case of a patent, yes, it absolutely is necessary because the statute creates the patent right, and until you get the patent granted from the patent office, there's no patent right established. In contrast, the trademark right is created by the activity in the marketplace, by the party who uses the mark in the marketplace. And the trademark system is recognizing that right and providing a framework for protecting that right. In the federal system, you can have what's called an intent to use trademark application, which may allow you to reserve some trademark rights prior to the actual use. The federal registration system, although it's not necessary in the establishment of the right, it confers many important benefits for making that right enforceable. And then the copyright, that too exists upon the creation of the work. But the registration with the copyright is very important if you are going to enforce the copyright. So, much of our work involves obtaining patents for inventors or their employers. So we'll briefly explain a little bit about what a patent is and how you get it. A patent includes two main parts. One part is a specification, which is a written description and possibly also drawings that describe the invention in a manner that is sufficient for the public to be able to practice that invention after the patent expires. So the amount of detail and information that you need to provide in describing the invention in the specification depends on the technology of the invention and how familiar people who practice in that technology are with the subject matter and how easy it would be for them to practice, to make and to use that invention. The second part of the patent is what we call the claims. And the claims are in some ways like the deed to a piece of property. The claims define the outer perimeter of what the inventor thinks he has contributed and is entitled to exclude other parties from practicing. In other words, the scope of activity that will infringe the patent if it is granted. So if you have an invention and want to apply for a patent, you prepare an application including the specification and claims. Most often you'll engage a patent professional to take care of that because you'll probably get a much better result than if you try to do it yourself, but in theory you can do it yourself. The application then is submitted to the Patent and Trademark Office to be examined. The application is assigned to a patent examiner who works in a relatively narrow area of technology and develops a certain amount of expertise in the technology. The patent examiner reviews the application to see if the invention is described adequately and whether the subject matter of the claims is different enough from the work that has been done previously in that area. In the patent language, we would say new and not obvious. So as often happens, the examiner finds a reason not to allow the application, and he will issue a report that explains the reasons why he doesn't think you're entitled to your patent. The applicant then has the opportunity to respond, and you can respond by explaining that the examiner has made some factual errors or applied the legal standards incorrectly. You may also change the scope of your claimed subject matter to enhance the differences from the previous work or to have a better correspondence with the description of the invention that you've provided in the specification. The examiner then will reconsider the application in light of the response and decide whether you're entitled to a patent or else issue another refusal with an explanation of why he doesn't want to give you a patent. In the case of another refusal, you can submit another response. As I mentioned, we're permitted to adjust the scope of the claims when responding to the examiner, but it's important to remember that new information can't be added to the application after it is filed. So any adjustments that we make to the claims have to be based on that original description in the specification. If the examiner still isn't willing to give us a patent and we're tired of dealing with the examiner, there are appeals processes available within the US Patent Office. And also there is the opportunity, if you wish, to go outside of the Patent Office and challenge the Patent Office's findings in the court system. So a patent application should be submitted in each country for which the inventor or the employer desires patent protection. There are international treaties that allow the patent applicant the opportunity to file the patent application first in its home country and delay the submission of corresponding applications in foreign countries for up to 12 months or 30 months, depending on which treaty you decide to take advantage of. This gives the applicant a chance to evaluate the importance of the invention before undertaking the expense of filing in other countries. It also gives the applicant an opportunity to update the application with any additional developments that they've uncovered about their invention since the first application was filed in their home country. And again, that can be done before you file the application in the US. You can add the new information at that stage, but not after you file it, have the application filed. So generally, the term of a patent is 20 years for the usual type of patent from the US filing date. The US patent system also has something called a design patent that permits a patent for the ornamental aspects of a useful article. This type of patent has actually been becoming substantially more important in recent years as a tool against counterfeiters. But the life of the design patent is 15 years from the date that it's granted by the Patent Office. I've never really been completely sure why they have different timeframes for the two kinds of patents, but that's what the statute says. So suppose you have a competitor who has a patent and you're not happy that they've got a patent that they might be able to use against you. What can you do about that? Well, there are different procedures available in the Patent Office for opposing an issued patent. The level of participation that the opposer is allowed and the expense of the procedure varies substantially between the procedures. Most pending US patent applications are open to public inspection. So you do have the opportunity to monitor the progress of a competitor's patent application as it goes through the Patent Office. There are some limited opportunities to provide information to the examiner of that patent application during the examination process, but these procedures are very limited and generally are not useful. Outside of the Patent Office, patents are also challenged and invalidated in court. So if someone accuses you of infringement, you can even start a patent litigation against the patent owner, or else you can challenge the validity of the patent as a defense if you are sued for patent infringement. A rough idea of some of the costs involved. The most expensive level for the opposition systems in the US Patent Office is known as inter-parties review. And typically those are costing $100,000 to $700,000. The typical cost to take an infringement lawsuit to trial is in the ballpark of $2 to $4 million. So we people don't undertake legal issues for patents lightly these days. And there are some possibilities to use both systems. That's a topic a little bit beyond what we want to talk about tonight. Okay, so we've talked about how to get U.S. patents. What's challenging if you're a company or university or someone in Japan who's thinking about getting a patent outside of Japan, and particularly in the U.S.? One is that the possibility of the enforcement litigation often is not at the highest level of consciousness for the patent professionals in Japan. There are a couple of reasons for that. The patent attorneys often are not lawyers. Also, the use of lawsuits to resolve the patent disputes in Japan is relatively rare. So for any patent applicant, there's a challenge to convey information about the inventor's or the company's purposes for an invention and the technical aspects of the invention to the U.S. patent attorney in a form that will be useful to draft a patent application, as well as to respond to issues that are raised by the examiner during the examination process. Likewise, going the other way, there are challenges for anyone in conveying requests for information from the U.S. patent attorney in a manner that allows the company's business and technical staff to understand what is needed for the U.S. attorney to take the steps that will obtain the patent protection that the inventor or the company is seeking. The language and cultural differences for Japanese companies enhance these problems. The time zone differences also contribute, although some of this is becoming less significant with our ability to have video conferences. But still it remains that if we are working with a local client in the US, it's very easy to call and talk to someone and resolve questions about what you're doing, as compared to the case of a client in Japan who's probably not in the office at the same time you are, who may have a limited ability or comfort level in English communication. And as a result, we see a lot more things done in writing. This sometimes results in incomplete communication. And also, the more you have in writing, the more things an opponent in litigation will have to look over and find reasons to attack if the attorney-client privilege associated with those communications happens to be broken. Another problem for the Japanese companies and other entities is that most companies do not have enough budget for the substantial review and revising of a Japanese patent application before it is filed in the US and other foreign countries. Usually, there's not much more than an opportunity for a little bit of fine-tuning. There are some basic similarities between US and Japanese patent systems, but there are a number of differences in the details that can have a significant impact on the protection that will be available in the US. And remember, we are prohibited from adding new information to the US patent application after it is filed. This makes it difficult to remedy any deficiencies in the Japanese patent application that are discovered after the US application has been filed. In essence, if the people preparing the applications on the Japanese side aren't very familiar, extremely familiar with the US patent system. There'll be a lot of things they just don't know. And sometimes what you don't know can hurt you when you assume that what you see in your own country is going to be handled the same way in a different country like the US. Finally, another challenge that the Japanese entities face is that historically there has been an institutional reluctance, especially by the companies, to share detailed information with people outside the company, and particularly with outside counsel, and even more particularly with a foreign attorney. That is a hindrance in the US attorney getting all of the information that might be necessary to achieve the results that the company is looking for. So how do the companies and universities and others in Japan address these challenges? One way, and it's the predominant way, is that they would use a Japanese patent firm as the intermediary for communicating with the US patent attorney. This is still by far the most common way for entities in Japan to pursue patent protection in the US. These Japanese patent firms really have a business model of assisting Japanese companies and other entities in obtaining patents in foreign countries. And so they typically will develop at least a basic understanding of the requirements for the patent systems at least in the larger countries. They typically are at least competent in translating English to Japanese and Japanese to English. Sometimes they will have other capabilities as well, but most countries around the world seem to have English as a second language, so that the Japanese patent firms usually can use English as they deal with, say, a law firm in France or Germany or something like that. A big part of what the Japanese patent firms provide is that they are comfortable in communicating with foreign attorneys, as well as with the patent staff or other personnel of their client in Japan. They are willing to ask questions about what the foreign attorney is doing to make sure that the foreign attorney is understanding what should be done, and willing to advocate on behalf of the client to make sure that the attorneys in the US are really understanding what the client wants for a particular case. Another important thing that they do is they provide docketing and file management capabilities. This is a very substantial service, particularly if you have a number of patent applications filed and are pursuing them in several different countries. It's a tremendous amount of paperwork, a tremendous number of deadlines to keep track of, and it's a very important service that these firms are providing to some of the Japanese companies and inventors. In the past, the Japanese patent firm had a lot of authority to choose the foreign firms that they wanted to work with. We've been seeing that this is changing recently, and the companies are starting to, especially the bigger companies, are exerting more control over the firms that should be selected as the partner firms in the US or Europe or other places. Sometimes the company will designate a limited number of firms that their Japanese patent firms can choose from when sending cases to other countries. Sometimes they're assigning particular product lines to particular firms so that they sort of increase the familiarity of the foreign attorneys with with their product lines and their business. And it also helps them strengthen the ties with the foreign firms and develop maybe a stronger loyalty with from the US or other foreign firms. Some Japanese companies have developed the in-house capability to handle their foreign filings and work directly with the foreign firms. Particularly some pharmaceutical companies have a long history of directly working with the foreign firms, but it is relatively rare, and it is something that is difficult to develop, particularly in a short time. We've seen that for some companies, it's been very tempting when they have a number of underutilized people in their patent department who they can't fire, to try and let them take over some of the responsibility for handling the foreign filing and not have to pay as much to their outside Japanese firms. I'll say the results are mixed at best in those situations. So, how have we seen the Japanese company changing their approach to patents in recent years? We're seeing that the patent quality is becoming important. This, I think, is due to an increased interest in having a presence in international markets. You're also seeing it result from more Japanese companies having ties and relationships with overseas companies, all of which makes the protection in the other countries become more significant and important. We're seeing some increase in the willingness of the Japanese companies to enforce their patents. Many times the patents are also used defensively as a sort of a shield or something that can be used to counterattack if someone sues them for patent infringement. But we're definitely seeing increased interest for the companies to try and monetize their patent rights, often through licensing, sometimes through joint ventures. We are seeing that the Japanese companies are becoming somewhat more selective about their pursuit of patent applications, both domestically in Japan and overseas. We've particularly seen companies becoming more strategic and selective about which countries they're going to file patent applications in for particular inventions. They're recognizing which areas of the world are most important for different aspects of their technologies and choosing, reducing costs by filing patent applications only in those countries. So we don't think that this is necessarily due to any less interest in research and development in Japan, but it does seem to reflect a different view of the cost-benefit balance for patents. And particularly, we are seeing, in contrast with 10 to 20 years ago, that there is not a sense that you need to have a huge patent portfolio to show that you're a healthy company with good prospects for the future. And just as to explain that a little bit more, if we look in the 20 to 25 year ago range and look at the numbers of patents that were obtained by different companies, in those days, usually there would be 5 or 6 Japanese companies in the top 10 US patent recipients. There'd be some change in who is in the top 10 and the order might change, but usually you'd have 5 or 6 from Canon, NEC, Matsushita, Panasonic, Sony, Hitachi, Toshiba, Fujitsu, and Mitsubishi Electric. Fast forward to last year, 2020, there were 6 Japanese companies in the top 30. Canon was number 4, Sony number 10, Toyota number 13, Panasonic number 20, Hitachi 25, and Fujifilm number 30. If we look at the top 3 recipients of US patents for 2020, it's IBM, Samsung, and LG. Each of them increased their number of patents by about 2.5 to 3 times their 2010 level. Canon's number of patents did increase, but it was only by about 50%, so a much smaller increase relative to what some of the other companies have been doing. We are also seeing more activity in US patents from smaller companies and universities. Part of this, I think, is an increased awareness of intellectual property, really worldwide, but throughout Japan, and new business opportunities for universities and smaller companies to reach some collaboration with companies or entities in other countries, so that the possibility of the US patent becomes more important as they are looking at possibly finding a business partner in the US. We're also seeing that the Japanese patent firms see the smaller companies and universities as a new business opportunity. In the past years, a lot of firms were happy to get work from the big companies, and that would be good enough for them. We're hearing that there's cost pressure and things like that that are making the Japanese patent firms a little more willing to look outside of their traditional sources of work to find new opportunities for clients. And so they are more active in reaching out into the smaller entities and universities and sort of selling the idea of patents further down the size line of the entities in Japan. Something else we're seeing is much more participation by directly by the company personnel in the patent procurement process. Even though they're still using the outside Japanese firm, the company personnel are more willing to engage with the attorneys overseas to help explain their objectives and make sure that everyone is understanding what they need to have done. We are also seeing that the Japanese patent firms are increasing their level of oversight. Part of that may be due to the fact that as an outside Japanese firm, you need to show value to the company. And if the company personnel are becoming more sophisticated, then as a Japanese outside patent firm, you need to increase your level of sophistication and service so that you are still adding value to your corporate clients. Okay, so suppose you're a law firm in the U.S. and you are thinking that, well, working with Japanese clients might be a good thing. Well, why would you want to? Well, there's several reasons why we find this a desirable type of work. We see a wide variety of technologies. So if you're interested in learning about a lot of different technologies, you see a very wide range of types of patent applications in this kind of work. From a business standpoint, this type of practice provides a relatively steady workflow once you have established the practice. So it provides a good base level of monthly income, that just continues. The Japanese clients are very good about paying their bills. Another reason you might want to engage in this work. I can hardly remember any instances where one of our Japanese clients refused to pay, an invoice. So it's very, very good in that way. So what are some of the challenges, though, you would face in trying to develop this practice? First, the Japanese side has a very strong preference for the status quo. So if you're a Japanese patent firm and you chose a particular US firm to work with one of your clients, telling that client that, well, now I want to start sending the work to this other firm in the US, that might suggest you didn't do a very good job when you chose the first firm. And so that doesn't make you look good. Then if you do make the change and something goes wrong, the person who was in charge of making that change is going to be very vulnerable. In a US firm that does not have an established reputation in working with Japanese clients is at a significant disadvantage in trying to obtain that kind of work. And especially if it's a firm that's not located in the DC, New York City corridor, there's an even bigger disadvantage. The historic perception is that the firm in the Washington area, maybe New York, because it had strong historic connections with Japan, but especially in DC, that's where the patent office is. They must know what they're doing. And so choosing a firm in DC is the safe choice. And if something happens to go wrong after you choose a DC firm, you can say, well, at least we chose the firm that everyone else in Japan has been choosing. So we had no reason to think they wouldn't do a good job. Now, of course, once you've established a reputation, a good reputation, then the status quo is actually very beneficial for you, and it works to your advantage. It's very difficult for an outsider to get any meaningful access to a decision maker. You don't run into someone at a cocktail party at a convention and find out he works for Sony, and 2 weeks later they've decided to transfer half of their patent portfolio to you. It just doesn't work that way, and it takes a lot of time to develop these kinds of relationships. If you are in a firm and trying to start this without any existing relationship with Japan, it's very important for you to have managed expectations, especially at the early stages. And it's very important, especially if you're in a bigger firm, that you have a firm management that understands the benefits that can be achieved later on and is willing to take the heat from other people in the firm when the practice isn't as profitable starting up. Typically, as a US attorney, you're going to pay all of the fees associated with the patent filing up front. Again, the Japanese clients always pay their bills, so the money comes back, but that in a lot of firms, that's a very difficult thing for them to do. You have to also be very realistic about the amount of work you're going to receive in the early stages. You have to be happy with a small amount of work for clients you may never have heard of, and know that doing a good job on that will lead you to become more trusted and be given access to more important work later. This kind of work also requires a relatively high level of clerical staffing. So again, your firm has to be prepared to undertake the expense and time of developing the staff that's necessary for handling all of the paperwork and the communication. You also need a very strong collaborative attitude within the firm. Different attitudes, different segments in the firm, such as the accounting and docketing department, have to be very cooperative and willing to work closely with the clerical staff and the attorneys. So some of the key points and challenges in having a successful relationship with our Japanese clients. One is understanding the strengths and weaknesses of the firm or client that you're working with. A big part of what we do is communication, and understanding who you're working with helps you decide what is the information that you need to provide them so that they can give you what you need to do a good job for the client. It also, as you develop an understanding of who your partner firm is, sometimes you'll have a case where, frankly, the arguments just aren't very good. If you know that the firm is generally pretty competent, you just know that this is a bad case and you'll have to do the best you can, and don't be writing back to them and asking, well, why can't you give us better arguments? You'll know that there just aren't any. When you're dealing with a Japanese patent firm, you have to be sensitive to their position as the middleman. The traditional business wisdom is you cut costs by cutting out the middleman. And the Japanese patent firm is going to be very sensitive to one of the foreign firms doing anything that might look like it's trying to cut them out of the loop. They can't do anything if their client initiates it, that's fine. But the foreign firm has to be very careful not to appear that they are actively seeking to work directly with the client and cut out the Japanese firm. The Japanese firm has the main contacts, and if they think you're trying to cut them out, they'll not have too much trouble in making it so that you won't get any work at all. Ideally, we are working cooperatively as a whole. The US firm has its role, the Japanese firm has its role, the company personnel have their role. And by working collaboratively and cooperatively, everyone can be happy and get the results that they want. Another thing that is for US people is maybe not as well understood is the level of attention to detail that's necessary. The firm may not be able to recognize a brilliantly crafted legal argument, but they can recognize that there are clerical errors in your papers. And the basic idea that they have, and perhaps with some wisdom, is that if you're making small errors now, what's there to believe that you won't be making more substantial errors later? And it's sort of a snowballing process. If they start seeing errors, they're going to start checking more carefully. The more carefully they check, the more errors they see. And so it's really very much easier to be very careful about your work and not give them a reason to start worrying about the attention to detail that your firm is providing. Basically, the Japanese firm wants no headaches. So that means no problems with the cases. Pay attention to deadlines if they give you deadlines. If they're having to write back to you and say, well, we asked you for this draft, they're going to become very unhappy quickly. The US firm also has to be willing to modify its internal procedures to meet the requirements of the Japanese firm or the ultimate client. The in a practice like ours, we're dealing with dozens of different law firms. Some of them have special communication systems. Others have different ways they like to have communications in the papers that they want sent. And you have to pay attention to it. You can't say, well, 80% of our clients want this, so this is the way we're doing it. They'll find someone else who will do what they want. And again, the expectation is that you will pay out of pocket expenses up front and wait for them to reimburse. And I think that brings us to Masako's section.
Hey, we are already 12 minutes, past. However, we have only a few, and my section is just 5 minutes. But before that, we received a question from Sayuri-san, and the question is if our company has many national people having different nationalities. For example, an inventor, for example, here, and then his or her supervisor is in other country. In such a case, if the inventor discuss the invention with the people in other countries, is that exporting the technology? That is probably related to the foreign license we need when we file the patent here in the United States. Then after, if we want to file application in Japan, we need a foreign license from the United States Patent Office. However, we have a lot of cases having joint inventors all over the world. So, Doug, do you think they should be careful about that?
I think they do need to be careful about that. I think, I mean, there's a whole body of law outside of the intellectual property law about the exportation of information, and it does need to be taken seriously. I'm not going to try and give you any information about the information export law, but there are ways to handle it. So in 30 seconds, my advice would be, yes, it's something that you should make sure is being done correctly. I think there are ways that you could handle the discussion, sharing of information between researchers in the US and other countries without too much trouble. But it is something to make sure that I think should be done to make sure that you're comfortable that you are complying with the US laws on that.
So, yeah, then I will come back to my just short, brief presentation. This is from my experience. Usually I am the person, if something happens in the firm with our Japanese client, then I discuss with the Japanese client and solve the problems. So problem solver standpoint, I just want to share my experience. The hard thing is if something happens, we made a mistake or you make mistake, that is difficult. So we are humans and we can make errors. When you make errors, you would feel uncomfortable and probably depressed. However, if you can solve the problem well, in a good way, your relationship with the Japanese partner can be improved. So stay positive. When you made an error, contact your Japanese partner immediately and disclose the error. Don't hide it until they discover it. As long as the liability is not involved, apologize for the error. The partner will calm down if you apologize, and don't make any excuses before apologizing and listening to what they say. It is important to understand that the position of your contacting person, Japanese counterpart in the entity, because their reputation might be damaged by your error. Think about that. For example, attorney in Japanese firm who recommended you to a corporate client, or IP person in a corporate client who chose you. So if you make an error, it not only your reputation, but their reputations might be hurt because of your error. Could you go to the next slide? Yes. So when you work with your Japanese partner, understand a different approach that they take. This portion is very interesting for me to work with a US firm and Japanese client. As a Japanese native speaker and a Japanese national. Japanese typically tries hard to prevent potential problems and errors before happening. They think of potential risks and take measures to prevent the problem from occurring. Their approach is so-called, I call it preventive approach. So there's no problems, no errors are normal. So that means if you make an error, you are lower than the standard average. So this leads to the less risk-taking behavior, I think. From my experience working in Europe, Japan, and the US, Americans and Europeans generally solve a problem after it occurred. So-called, I think, a corrective approach. So understanding that your Japanese partner may have a different mindset from yours, that would be useful. So based on the preventive approach that Japanese partners have, so they often are not satisfied with just solving the problems that happened. So that actually, I have several experiences, unfortunately. They expect that you change your process or procedure to prevent the same error. Japanese call that the kaizen. So we try, of course, our best not to make any errors, but of course we are humans. Sometimes we make error. One time our staff made a clerical error in a patent case. So it would have a consequence. However, as soon as we recognize the error, we fixed it. And there was no consequence from the error. And we solved the problem. And of course, we apologize to the Japanese attorney who is in law firm immediately by email and later in person. Our corporate client requested kaizen to avoid recurrence of the same error. So, and Doug proposed a sudden change of our procedure. Then the corporate client was very happy and satisfied with his proposal, and the Japanese attorney in between us and the corporation also are very happy with the outcome. And we are working for the corporate client and attorney still now, long time after the error. So we work with the client through a Japanese law firm. In that case, imagine that Doug presented his proposal to the Japanese attorney, and the attorney presented his proposal to the IP person of the corporation. And the IP person presented the proposal to his or her boss. So in this regard, the Japanese attorney and the IP person were on the same boat with us. Depending on the situation, the corporate client might discontinue to work with the Japanese attorney, and or the IP person who chose us might be demoted, particularly if the matter is serious. So we needed to save their reputations too, not only ours. So that is what I always thinking of. Thank you. And could you go to the next slide? So then I'm always thinking of these kind of things when I communicated with a Japanese client. The first thing is respect and listen to what your Japanese partner said. So be flexible to modify your process or procedure. Pay attention to details. Confirm that they fully understand what you said. Japanese often doing nodding, but nodding does not mean understanding. make sure, and making a question from them is rare. So making questions to them and be patient. Your partner's process of making a decision would be different from in the US. It would take time. So lastly, don't forget smiling. Thank you very much.
All right, thank you so much. This is the sign language for clapping. So because y'all are muted, so we can do this right now. Thank you very much. Did you guys have any other questions? Are you guys okay? Yes, we're getting a lot of thank yous. So thank you very much for everybody from HSML. And yes, so before we go, we would like to take pictures together. So if you don't mind, can you turn your camera on so that we can do the pictures? That would be great. Just those of you that who doesn't mind being in the pictures. Yeah, pirate is welcome also. All right. Do we all have everybody? Okay, so let's do good old traditional cheese. Ready? 1, 2, 3, cheese. Yoko-san is okay? Yes. All right. Thank you very much again. And thank you to everybody that who joined us today. And for the future event, please check out our gala. It will be on our website. It is actually on the website right now. So please check it out and we'll see you in a different event soon. Please take care. Have a good night.
Bye. Thank you.
Thank you.
Thank you so much. トイレに行きたい。お疲れ様です。じゃあ、おやすみなさいかな。大丈夫かな。はい、お疲れ様です。